In this segment, I'm going to define the terms fiduciary and stewardship as they're commonly used today in society, and as well, we're going to take a look at what their meaning was 500 or more years ago. We're going to go back to their origins. We're also going to discuss fiduciary rules in context of wealth management, briefly, as the next 10 years will witness the greatest wealth transfer in American history, and fiduciaries, both good and bad, will be all over this money, as will pension funds, where most American savings now resides. And in your capacity as an outside advisor or inside the corporation as a risk manager, as a compliance expert, or within the corporate legal team, you will probably have responsibility and oversight for your employees' pension plans. Those are the 401k plans today in the for-profit enterprise arena, in the 403b area for the not-for-profit enterprise. And as a fiduciary, one of the dilemmas you're going to face is whether to allow your employees to invest 100% of their retirement savings in your company stock because you really believe it is a tremendous enterprise. And you were given stock options, perhaps, for, say, the new startup that you have just joined. The question as a fiduciary is, will you follow what the executives and fiduciaries at WorldCom did? Will you speak up and argue that no employee stock should be held in a pension plan of the retirees because you have that fiduciary responsibility? What's sad, in fact, is at WorldCom, because 401k plans are not guaranteed by the PBG's Pension Benefit Guaranty Corporation, the retirees went bankrupt. You'll probably be on a pension board and have to make that decision, and it's an ethical one. Now, many of you have had courses in contract law, business law, have studied agent principal law and the duties of the agent. So this is going to be a very light treatment in this area. Of critical importance, however, is regardless of what the securities laws say, regardless of the Model Business Corporation Act says, I would argue strongly that you are a fiduciary with stewardship responsibilities of the corporation. So let's take a look at some of the definitions of fiduciary, and I'm sure you've seen this before. It comes from the Latin fiducia, meaning trust, a person or a business like a bank or stock brokerage who has a power and obligation to act for another, often called the beneficiary, under circumstances which require total trust, good faith, and honesty. Or another definition is a fiduciary is an individual in whom another has placed the utmost trust and confidence to manage and protect property or money. Well, let's take a look at Jim REGOS, who's an attorney CPA and does the bar review and the CPA review programs. Let's take a look at his approach to fiduciary responsibility. And he looks at it in the context of probate trust agreements. Fiduciary services, as he says, are growing, and the transfer of wealth will increase as the baby boomers inherit their parents' wealth. In addition to the heightened duty of care level, the potential dollar damages at risk in these types of engagements are often quite large relative to the fee. So what are the fiduciary roles? Serving as a personal representative in a probate, estate, trustee, or of a trust, or a receiver in bankruptcy are examples of this fiduciary role. Managing an elderly client's assets, directly or indirectly under a power of attorney or guardianship usually qualifies. These involve discretionary judgments, decision-making authorities, and it results in potential risk. The winners or losers are the beneficiaries who have no decision input. And that parallels a lot with the stakeholders of today's modern corporation. Duties of a fiduciary. There's a duty of loyalty to both the corpus and the beneficiaries, impartiality, equal treatment to all beneficiaries in a class, proper allocation between income and corpus interests, keeping the accounts up to date and accurate records must be maintained, and personal service. You can't delegate that duty, it's just not allowed. The utmost good faith is required, and some of the New York State laws require, and of course this is limited to New York State, dictate that many of these roles impair the independence of the fiduciary if the fiduciary is a CPA. Now, I mentioned CPAs because I think we could substitute, in this case, attorneys and CPAs for conflicts. Any personal transactions by a CPA or an attorney with the entity is suspect, including loans from the fiduciary entity. Now, as you may know, that is a common practice in large corporations where the CEO or others actually take loans from the corporation. Or maybe they're given a house and the corporation lends them money to buy the house with an interest-free loan in the event that they leave. A partnership or asset commingling with the entity is also not usually allowed. Trustee self-dealings, employing persons or entities related to the fiduciary, unless specifically authored in the governing document, investing trust funds in entities related to the fiduciary, and all borrowings from the trust funds, even with disclosure, are disallowed. And it may be prudent to advise beneficiaries to retain their own advisors. Let's take a look at another fiduciary area where, and this was a course that I saw relating to sports agents. There's no better place to start with a few definitions and principles, which come from the Restatement of the Law of Agencies of the ALI, the American Law Institute. Agency is the fiduciary relationship that arises when one person, a principal, manifests assent to another person, an agent, that the agent shall act on the principal's behalf and subject to the principal's control. The agent manifests assent or otherwise consents to act. So what is the effect of using the word fiduciary in describing this relationship? Here are some of the general fiduciary principles. An agent has a fiduciary to act loyally for the principal's benefit in all matters connected with the agency relationship. Duty of care, competence, and diligence. Subject to any agreement with the principal, an agent has a duty to the principal to act with the care, competence, and diligence normally exercised by agents in similar circumstances. Special skills or knowledge possessed by an agent are circumstances to be taken into account in determining whether the agent acted with due care and diligence. That's absolutely critical within the corporate structure. If an agent claims to possess special skills or knowledge, the agent has the duty to the principal to act with the care, competence, and diligence normally exercised by agents with such skills or knowledge. An agent has the duty within the scope of the agency relationship to act reasonably and refrain from conduct that's likely to damage the principal's enterprise. And I'm using this as an analogy to you as a fiduciary or as an agent working for the corporation as the principal. Conflicts of interest. And I think we see this all the time within the corporation. A cornerstone of agency law, and again, I'm using the metaphor of agency law with respect to corporate law, is that the agent must avoid a conflict of interest with the best interests of the principal. An agent who stands on both sides of a deal will be viewed as breaching the fiduciary duty at best and may be liable for fraud, failure to affirmatively disclose the conflict. For example, an agent who has undisclosed ownership interests in a team or in a company where the agent is representing the player in negotiations with that team or encouraging an investment in the company would have a conflict. Now, that may seem a minor point, but a couple of years ago, the CEO of Chesapeake Energy, one of the largest, most successful, fast-growing energy companies, was double dealing with a company that he owned that he did not disclose in the millions of dollars. So this is a classic case of agent-principal relationship that can be used as a metaphor for your responsibility within the corporation. So I'd like to discuss a little the Department of Labor's fiduciary standard, because I believe this fiduciary standard, if adopted by the SEC, will have much greater impact on corporations. The DOL principally focuses on pension and retirement plans and was first, as I mentioned, to enact a fiduciary standard of advisors to plans. Now, the question I ask you in your future roles in compliance, in risk management, as outside advisors to the corporation? Are you going to be the gold standard trusted advisor for the company? Will you act ethically, honestly, independently, and responsibly? And are those, in fact, goals that you would even think of when you're acting in your capacity within or outside the corporation? The Department of Labor proposed regulations that will put the interests of their clients above the interests of advisors. It's called Fiduciary Conflict of Interest Rule, Retirement Investment Advice Proposed Rules. This was proposed Federal Register, Volume 80, number 75, April 20th, 2015. It goes into effect. It was fought against by registered investment advisors, by financial planners for over 10 years. And there's some possibility that it might be amended after the elections. But the perspective is that the fiduciary rule would define who is a fiduciary of an employee benefit plan, or we could say who is a fiduciary of the corporate trust. What I'd like to do now is talk a little about stewardship. Let's define it briefly. Basically, the concept of stewardship first appeared in England during the Middle Ages. It functioned as a job description, believe it or not, denoting the office of a steward or manager of a large household. Over the centuries, its range of reference spread to the oversight of law courts, employee unions, college dining halls, Masonic lodges, and many other organizations. In recent years, long-established management sense of stewardship has evolved a positive meaning: careful and responsible management. The sense is commonly found nowadays in contexts such as stewardship of the environment, the family business. It also occasionally appears as an adjective in phrases as stewardship fundraising, that is, fundraising aimed at building good relationships with donors in order to keep them liable. It's first used in the 15th century. Another definition of stewardship is it refers to the responsibility of taking care of another person's property or financial affairs. In religious orders, stewardship refers to taking care of finances. Generally, stewardship refers to an employee taking care of the domestic affairs of a household in ships, aircrafts, restaurants, and trains. Stewardship refers to the job of employees taking care of the passengers' affairs. So let's talk about who the stakeholders are in the corporation and whose affairs you have to take care of. Let's talk about your fiduciary responsibility in the corporation and what your fiduciary obligations are to the publics you serve.